Sit at the table. Good morning, Your Honor. This is our relator, Glen Morgan, who's behind me on the table.
Good morning.
Dimitri Blitzen, Your Honor, for the
I'm here with the Island County now.
Island County Democratic Central Committee PAC here.
Thank you. So we are here on the plaintiff's defendant's motion to dismiss. The papers were stacked incorrectly. I'll indicate that I've reviewed everything that's been submitted associated with this. I will also indicate that I will not be swayed by accusations of the weaponization of campaign finance laws in Washington State or any sort of partisan allegations whatsoever. They are irrelevant to the issues the court is to decide this morning. So if we could focus solely on the statute and not focus on either that or any factual allegations regarding the volunteer nature and lack of experience of the individuals associated with this. Simply put, we have some very discrete but interesting legal questions that are to be decided on this motion. It is the defendant's motion, so I'll hear from the defense first. My first question to you is, we really have no guidance in Washington State about what to do in these circumstances, is that correct?
So actually, Your Honor, I was looking at this stuff again yesterday. Dimitri Blitzen, Shereen Keller, Bernard Blitzen, with me is Lori Ewan. I actually think that this, as you said, there's a very discrete legal issue here, and we do have guidance, and that is on the priority of action rule argument. And I actually think that this case is most easily disposed of.
And that's the Washington Education Association
It's
case?
actually the Yakima, the firefighters versus City of Yakima Supreme Court decision and the WEA, the Freedom Foundation versus WEA case. And if I can just address those very simply. In the firefighters versus Yakima case, the firefighters filed a charge with PERC, Public Employment Relations Commission, an administrative agency, against the City of Yakima. The City of Yakima then filed in the Superior Court for a declaratory ruling on the same issue.
Okay, so the characteristics of PERC are such that upon filing of a charge, a case is effectively started. Isn't that the way that PERC works? The adjudicatory functions of PERC, those wheels start turning once you file a charge, right?
Correct.
And that doesn't happen with a PDC complaint.
Right, which is why, but I think we need to look at the two cases in order. There's, certainly to answer your question, the facts of this case are not exactly the same as either of those. But the concept of the Yakima case is both PERC and the Superior Court have concurrent jurisdiction. And the Supreme Court ruled that in that case, because the dispute was first submitted to PERC, PERC had jurisdiction, or retained jurisdiction, as opposed to the Superior Court under the priority of action rule. Well, the reason I'm emphasizing this is that there's been some suggestion, well, look, the statute says this court has jurisdiction over citizen suit. That's true. But the question is, when two entities have jurisdiction, who gets to keep it?
And those jurisdictional wheels are turning. I mean, that really,
Right.
this is as if
Right.
King County Superior Court and Thurston County Superior Court both
Right.
had cases.
Right.
There's things going
So
on. But here we have a PDC complaint.
But so that's where we get to the WEA, the Freedom Foundation versus WEA case, where, since we were talking about an amended allegation about money from NEA to WEA, the Freedom Foundation in that case, interestingly, filed its complaint with the Attorney General. The Attorney General referred it to the PDC. And all we are told in the case at 111 Washington Ave. 604 is the PDC took an administrative action. I'm sorry, I didn't mean to go too fast. In the case, all we are told is the PDC took an administrative action based on the allegation. The AG refers it to the PDC takes an administrative action. Then when the Freedom Foundation seeks to add this as a claim in the Superior Court lawsuit, the Court of Appeals says no. The PDC, by having had the case referred to it and taking an administrative action, retains exclusive jurisdiction under the priority of action. Now, the facts of the instant case are much more compelling even than the facts of the EFF versus WEA case. Because in that case, the Freedom Foundation did not go to the PDC at all. In that case, the Freedom Foundation actually went to the AG, and the AG handed it off to the PDC. In this case, Mr. Morgan filed a complaint with the PDC.
In the Washington Education Association case, wasn't there an indication that the PDC would file administrative charges against?
There was a letter from the AG to EFF saying the PDC is going to. There's nothing else in the decision that I see indicating that that had happened ever or specifically before the ruling. They didn't say because the PDC filed charges.
So what's the administrative action that's being referred to?
I don't know. But I know in our case, the PDC initiated an investigation.
Do they ever not send that letter out to people when complaints have been filed?
So that's not in the record. I would say that especially in the last couple of years, it's kind of a new world with literally hundreds of complaints that have been filed. And I will represent that, I think it'll be undisputed, that this approach of Mr. Morgan filing a complaint with the PDC and then forwarding it to the AG has been his practice. So everything is landing on both the PDC and the AG's desk. To me, what is significant, what makes this easy, recognizing I don't know what the administrative action was that the PDC took, although we can infer that it wasn't the PDC has brought a civil suit in a superior court, or surely the court would have noted. You have two courts and two proceedings. So it was something less than a suit. Could, I suppose, have been some kind of notice of citation or intent to do something, but all we know is it was administrative action. But I think it is significant, since the point of the priority of action is that something's called a choice of forum kind of thing. In this case, Glen Morgan chose the PDC. He chose it first. He chose it at least 2 months before this lawsuit was brought. And we know that the PDC commenced an investigation. I will again represent to the court that when a civil suit is filed, the agency typically stops spending its resources on it. It knows that it's in another place. Hasn't closed that investigation. There's no question that if this case is dismissed, that
Are you aware of the PDC taking any action other than forwarding the complaint and asking for a response?
I don't remember. There might have been a little bit of back and forth email, but certainly nothing substantive, no filing of, the PDC did not bring a suit. I'm not sure what else it might have done. But it is our position that the combination of Glen Morgan filing a complaint with the PDC and the PDC taking the action of initiating an investigation is an adequate assertion of jurisdiction by the PDC if such action is necessary, that it is appropriate and equitable and consistent with both the Yakima case and the WEA case, that this court should decline jurisdiction in favor of the PDC. And again, while it is true that in the Yakima case, the firefighters had filed an unfair practice charge, there's no evidence in the Yakima case that that charge was processed, that here, as I recall, I'm pretty sure I'm stating the facts, I don't recall any evidence that. So the first step in a PERC charge is PERC has to do a preliminary determination of whether the charge has enough possible merit to state an eligible thing. I don't remember being any evidence in the Yakima case that PERC had done any of those things. The Supreme Court simply said, a charge was filed with PERC. They didn't actually say PERC has taken an action. Now, I agree with you. One could know from the regulations what PERC would do, but I don't respectfully think that the test is, has the administrative agency taken an action such that would allow us to say, well, if the administrative agency had filed a citation, then it has jurisdiction. And there's a, versus if it just starts an investigation. Here's the problem with that. It creates a completely undeterminable line. So for example, I filed a complaint with the PDC. PDC says, we are starting an investigation. That investigation would tend to have a lot of back and forth, might have discussions about settlement before filing a citation or something. Unless the rule is, if you submit a complaint with PDC, you've elected your forum and the PDC takes precedence over Superior Court.
Is that your forum? Are you a party once you file the PDC complaint like you are in PERC? In PERC, you're a party vis-a-vis the other side. In the PDC, is it your forum?
No, I mean, I wouldn't normally characterize it that way. It's an administrative agency. I understand the distinction you're making with PERC, and that's one of the places where I get to practice. But that gets back to the WEA case, which clearly wasn't troubled by that. If WEA could have said, well, that's a different kind of process than PERC, and therefore we're not going to apply the party of action rule. WEA says PDC, not the charging party, but PDC. I mean, I guess what I'm struck by is in the WEA case, the complaining party had never asked to have its case heard by the PDC. They sent a letter complaining to the AG, and the AG referred it to the PDC. And the Court of Appeals still said, you know, it's at the administrative agency now. Frankly, you could make equitable arguments about choice of forum that would have been much stronger in the Court of Appeals case, in the WEA case, where Freedom Foundation could have said, but we never wanted it to be an administrative agency. Getting back to what I was saying before.
So the priority of action doctrine states, the forum that first gains jurisdiction over a matter retains exclusive authority over it.
Right.
Is the act of a citizen filing a complaint some jurisdictional moment where it spreads jurisdiction pixie dust on them, or couldn't the PDC of its own volition investigate or become aware of something to take enforcement action?
This is exactly what the WEA case holds, because in that case, nobody filed a complaint with the PDC. The Attorney General referred it to the PDC. The PDC, I suppose, could have said to the Attorney General, we don't want it.
So what's the moment that the forum first gains jurisdiction?
When some entity, apparently not just Glen Morgan, but even the AG, when somebody hands it to the PDC prior to a lawsuit being filed in the Superior Court, then the PDC has jurisdiction.
So the passing of the baton, so to speak, is the passing of
Well,
jurisdiction.
I mean, to me, it's interesting. It was really a passing of the baton in the WEA case from the AG. It was, as I said, the facts are simpler in this case because the baton was just, I mean, the starting gun was simply a complaint to the PDC. I think that the only line drawing that makes sense to say, and it's, again, easier in this case, is if you file a complaint with the PDC, you have signed up for the ride with the PDC. You can't file a complaint with the PDC and 2 months later file a suit in Superior Court. And if we think about the social policy, the reasons for it, we don't want people, frankly, to do what happened. We don't want people to be filing complaints both with the PDC and the AG, having a PDC spending resources, investigating, potentially bringing an action, simultaneously having the Attorney General possibly bringing a lawsuit or a citizen's suit. That's precisely what the priority of action rule is supposed to prevent. Again, the facts here are easier and more straightforward than the Court of Appeals in WEA, where at least the Freedom Foundation has said, but we only wanted one forum, the state and ultimately the court. In this case, Glen Morgan chose to submit his complaint to the PDC. And therefore, I don't think there's any injustice under any analysis saying, yes, the PDC then received or exercised, if one wanted to say, well, there had to have been some affirmative action by the PDC that would sort of perfect its acceptance of jurisdiction. And there's some suggestions in the cases that that might be an appropriate line to draw. Then initiating an investigation is clearly across that line. And I would submit that it's impossible to draw any other line, because you don't want to say the PDC could investigate and negotiate and all these things, But if 6 months later, it hasn't yet filed an action, an enforcement action, it still doesn't have jurisdiction and the Superior Court could move ahead. That's clearly bad policy that's not consistent with the case. And I say, all I see in the WEA case, and maybe I'm missing something, is the PDC took an administrative action. But I don't even see that in the Yakima case. I don't see that PERC took any administrative action in the Yakima case, even if one might posit that it would have. The analysis could have been in the Yakima case. Firefighters filed a charge with PERC. PERC has so far done nothing. Let us posit that PERC has not even issued a preliminary ruling. And now the city of Yakima has filed a lawsuit for declaratory judgment. The Supreme Court in Yakima could have said, well, PERC hasn't done anything yet, so the city gets to go to Superior Court. But it's actually the facts of that case are so interesting because what was really happening, the firefighters said, we want this resolved by an administrative agency. And the city said, we want it resolved by Superior Court. And all the Supreme Court did was said, firefighters got there first. They got to PERC before the city got to Superior Court, both at concurrent jurisdiction. They didn't say, well, because PERC has acted, because PERC has geared up some kind of fact-finding procedure or hearing, they just said, you know, sort of race to the courthouse administrative agency. In this case, Glen Morgan raced himself to the PDC. He did not have to file a complaint with the PDC to sue Island County PAC in Superior Court. He could have simply filed a complaint with the AG, and if the state did not sue, then he could have brought this suit ex rel the state. So I don't want to belabor those points. I think I've made my argument clear.
Are we still maintaining the argument that the solution is meaningful in this case?
Absolutely.
Okay. And then what's the position regarding attorney's fees?
Well, I
Do
think
you believe that the court doesn't, it would be inappropriate for the court, even if the court were to say that fees cannot be directly awarded against the defendant, to maintain the issue of attorney's fees in this case to assess the reasonableness? Do you think that would be inappropriate in this case?
Well, I think that there's probably a necessary party if the plaintiff were to prevail and be entitled to attorney's fees under subsection 4 from the state. If I were the state, I'd go, wait a minute, Your Honor, before you assess attorney's fees against us for the reasonableness, I would think that the state would be a necessary party. I didn't argue in this case that it should be dismissed for lack of necessary party, because as are the cases, there has to be a certainty that you're going to get there, and I expect that we won't. I think it would be useful when this case goes up on appeal to have Your Honor address the attorney's fees issue, even though I'm quite convinced that we should wait on both the priority of action rule and the fact that, I mean, I was about to introduce myself as, it's a little odd, I got paid by this PAC before it went out of business. There was an understanding that I would do what I could to sort of make sure their name wasn't, you know, dragged through the mud. But they don't exist anymore. And I don't understand, as I said in the pleadings, I actually literally don't understand what would happen next if you did not grant the motion to abate, because the money's long since run out. I'm not going to be responding to discovery for a defunct entity, and a judgment against a defunct entity is not collectible. And there's that FEC case, that federal case, that reached exactly that holding. You know, if it's defunct, it's just, you can't do it. There's no point in doing it. But as I literally don't understand. I frankly don't understand. Apparently, there's, you know, we've cited statutes that, by statute, the state has changed the rule about corporations, and you can sue a defunct corporation. I don't actually understand how that would work either, but it might be in bankruptcy. There might be some other theories of collecting from related entities. But the common law seems very clear. You can't sue a defunct entity. To me, that's only logical. And I just want to be clear. There is no theory that people who donated money to this PAC when it was operating, or even the officers of the PAC, they were not named in the 45-day letter. They are not sued in this action. There is no theory that individuals who take part in a political committee have personal liability for the wrongdoings of that committee. You can scan 25 years of PDC findings and AG actions. So absent that kind of a theory that in this case, anyone is sued but this PAC, and given that the PAC filed its terminal C4, it shut down, it has no money.
Well, and how does the termination mechanism actually work? Do they just file the terminal C4 and it's just it's just done, or is there some additional action from some other entity?
No, there are certain prerequisites. They have to have zero money left, and there are a couple of other record-keeping things, and then they file, just like you create a PAC by filing certain documents, C1PC, say, we want to be a political committee. And then you are obligated, serious obligations to report timely and properly. And then you file the terminal C4, and you don't exist anymore. And I do want to say, because I do a lot of political work now, I'm hired by a ballot measure committee that has a measure on the ballot for November of 2018. And it had never occurred to me, it still doesn't, if November of 18 comes along and they win and they lose, and they have spent every last penny trying to win the ballot in November, and I send them a bill and they say, we don't have any money left, we've shut down, it had never occurred to me that I could sue somebody like the then no longer extant ballot measure committee. Well, you have to pay me. If I'm foolish enough to not get the money up front, I'm not going to get paid.
So what if they violate every campaign finance rule as they go along, then dissolve on election day? Is there no need?
So there are situations where the PDC, and I'm thinking of a case with a company called Moxie Media a couple of years back, where the PDC worked out an agreed settlement, and then the commission rejected it and went to the AG and they sued. And they sued the principals of Moxie Media, saying, you intentionally designed an unlawful scheme that would hide the source of campaign contributions. So there could be a theory, if there was any evidence or allegation, for example, that somebody in fact created this PAC with an unlawful intent, or even while running the PAC, unlawfully, intentionally violated the law. There are both criminal and civil actions that could be taken against those people. But that is not the allegation Glen Morgan made. His allegations are solely against the committee, qua committee. I hardly ever get to use that word, qua. The current campaign finance laws are replete with provisions that could be the subject of meaningful discussion about whether this law works, quite frankly. In fact, it's probably no surprise to you to know there's legislation being argued about in Olympia as we speak that would amend this law. There are lots of things about it where one could say, well, that doesn't seem like it makes a lot of sense, and then which the response is going to be, well, it's kind of for the legislature to fix. Now, to be fair, for 22 years, there has not been, to my knowledge, a situation where a committee was alleged, for example, by the AG to have violated the law and then went defunct. And the AG went, well, what do we do now? That issue would have perhaps been brought to the legislature years ago, but it had happened years ago. So you can say this law has actually worked effectively for however many years it's been since the initiative was passed. That apparently is not a problem. Has not been a problem. If the legislature thinks it would be a problem because of this case, so be it. But as a matter of statutory interpretation, I don't think, which is what I understand the opposing argument to be, I don't think you could say, well, that can't be what the law means because of that particular bad outcome. We can't say, well, there's no other remedy. And as I say, the most obvious example is if there was any evidence of intentionality, there are other remedies that the AG and the PDC would have. So we're dealing with a pure situation where a political committee allegedly disputed, failed to meet the somewhat arcane filing requirements of the Fair Campaign Practices Act, and run out of money, doesn't have any way of, realized it didn't have any way of getting more money, and I'm trying not to get into those facts, but in fact, it had no money, and it shut its doors. I think the burden is on the plaintiff to suggest that the legislature, the initiative and then the amendments somehow intended there be some follow-up step against a defunct committee. And because, as I say, I can't even think of what those follow-up steps would be, other than them obtaining ultimately a default judgment, and then asking you to impose a penalty on the committee. And then you have to decide, well, am I really spending the time of Thurston County Superior Court imposing a $3,000 fine on what used to be the Highland County Democrats political committee that doesn't exist, that no one's ever going to pay? To me, it's not very irrational to say if the committee doesn't exist anymore, the lawsuit should be paid.
Thank you. I'm going to take our 15-minute morning recess at this time for the benefit of our staff, and then I will hear the other side. Court's in recess.
Thank you.
All right.